Hello, everybody. Welcome to the September Homeline webinar for our ongoing tenant landlord law series. We're going to be talking about going to conciliation court today, which is both intertwined with tenant landlord stuff, but also its own beast. So some good landlord tenant adjacent things here. Going to just give it about 30 seconds here to let folks come in before we get started. There's a lot of information on these slides, so I want to make sure that we give everyone enough time to get through everything and we're not rushed at the very end of this. So, okay, I think I see that we've slowed down, so I'll go ahead and get us started here. I have it at 1:31 right now. So again, thank you everyone for coming today. This is Homeline's September installment of the ongoing tenant landlord law series that we've been doing for the last several years now. Today we were going over basically a quick guide to navigating small claims court, also known as conciliation court. For those of you who aren't familiar, Homeline is a statewide nonprofit organization. We help tenants kind of navigate what their rights are under Minnesota tenant landlord law. As of just, I believe it was yesterday, I got notified that we have upped our numbers. We've advised over 329,000 renters since our opening in 1992. We offer, like I said, offer free confidential legal advice in 4 languages, including Spanish, Somali, and Hmong, as well as English, and we have an email and attorney option. These are those phone numbers and how you would access our email form if that is your preference. Just a couple of housekeeping things here before I turn it over. So we do have some upcoming webinars. Like I said, this is an ongoing series. Next month, we'll be having folks come in from it's Mid-Minnesota Legal Aid, talking about new shared meter regulations that are going to be implemented starting in January of 2025. So it's a whole new basically chapter of law that's going to be impacting tenant landlord, specifically like shared meter for utilities and stuff. So that is going to be a really helpful and great webinar for us to kind of get a grounding on what the new rules are going to be. And then November 13th, we're also going to be having folks coming in from the Housing Justice Center to talk about the new law that will be coming into effect again, January 2025, kind of going over the tenant's right to organize that is also being codified into law and again effective as of January. So both two kind of really great important webinars coming up soon. So learn more, you can register and learn more at homelinemn.org. That's our website. A couple more housekeeping things. So this session is being recorded and it's going to be available on our website in a few days as soon as we get it all off of the cloud and all of that good stuff. We'll also include a PDF copy of the slides so that you can reference back to them through that. Please ask your questions through the Q&A function. That's located at the bottom of your Zoom window. I will be posting a lot of links and things into the chat itself, and so we'll probably miss any questions that are given in there. I will feel badly about it, missing them, but I will likely miss them. So the best way to get a question answered if you have a question throughout this is to put it in the Q&A. And then 1.5 standard CLE credits are going to be applied for this session if you are an attorney or someone who needs CLE credits. If you don't know what that is, you probably don't need them, and I wouldn't worry about it. So at this point, then, I'm going to turn it over to Dan to share. So just give me a second while I do that. All right, so I'm going to stop share. And then Dan, you should be able to share. All right, fabulous.
All right.
All right.
So you're going to see a border there. That's because we're using presenter view, but I think this is the best way to manage it. So now I'm going to turn it over to Matt. Take it away, Matt. Matt, the
Hey, all
lawyer.
right. We're like the greatest tag team ever been in legal professions. Yes, I'm Matt Eichenlob. I'm one of the attorneys here at Homeline. I've been here since 2008, and this is what I've done for the last 16-ish years. So let's get into it. Um, I'm going to do just sort of a general sort of overview of what we'll be talking about. We're going to talk about conciliation court and judgment enforcement. That's the real meat of what we're talking about today. We're going to go through filing the statement of claim. That's the document that you use to start the case. We're going to talk about who exactly are you suing. There's some big differences in filing and service, how something is filed, how something is served on the opposing party, and $2,500. That's sort of the cutoff where the differences are. The smaller amounts the court handles, the larger amounts need to be done personally served. I feel like I'm giving away the last chapter of a detective novel here, but it's okay. It's all right. We'll talk about some evidentiary tomfoolery, skullduggery, mishigas, right? The things that you need to prove when you're at court. We're talking about the preponderance of the evidence. We'll talk a little bit about preparing for the hearing. Settlement negotiations are always part of going to court, and removal. Taking what if you don't like the result from the court, and that's sort of the first half of the program. The other half, maybe more like the second third, is the judgment enforcement. What do you do when you win? How do you actually get paid? And that's going to be docketing the judgment, um, orders for disclosure, orders to show cause, locating where those assets are that you can seize, um, adding increased cost to the judgment because it takes time and effort to collect, and then sending out a satisfaction of judgment once you've been paid, closing the case essentially. So that's really what we're looking at. We're looking at that's really the life cycle of a claim from when you file it to, if you win, getting paid and closing the case.
So my name's Daniel Suter. I use he, him pronouns. I'm a housing attorney here with Homeline. I've been here for 3 years now. I started when I was in law school as a part of a fellowship program. And, here I am to this day. I have less experience than Matt, but the one thing is every single attorney or tenant advocate at Homeline has talked a lot about security deposits and other conciliation court claims. This is a huge part of what we do, and it's something we're really used to advising tenants on. But what is conciliation court? Well, that's our special name for small claims court in Minnesota. So if we're talking Minnesota law and somebody says conciliation court or small claims court, it's interchangeable. I'm not going to get too much into this, but there's a general philosophy that says, people really need to have access to justice for their claims, whether large or small. You may have heard there's no such thing as a small part, only a small actor. It's pretty much the same thing is true about civil claims. And that's what this is really about, civil claims. This philosophy here, the providing a convenient forum for resolving claims which would not be brought normally because of the cost and delay in a full civil proceeding, is precisely how we see conciliation court used here in Magna Carta. If you're one of my friends counting my academic ticks, this really does date back to the Magna Carta of 1215. Access to justice, access to the courts. It's a pretty straight line, actually. Minnesota's had a small claims court since 1921, and it's called conciliation court because it used to be that there was a difference between conciliation court and small claims court. A conciliation court in structure was originally intended to really be more like mediation. Back in the 20s and 30s and 40s, we didn't have as much of a formal legal structure around mediation. And so small claims in Minnesota, kind of that Minnesotan go along, get along attitude, was intended to produce cooperation and settlements, really. That changed eventually, and now this is basically it's civil court junior. The jurisdiction of small claims court is somewhat limited. In conciliation court, you can only sue for economic damages, essentially, of $20,000 or yes. That's an update. It used to be $15,000, and the last legislative session updated it to $20,000. You cannot sue in small claims court for defamation, medical malpractice, to get ownership of real estate, or other equitable relief, such as an injunction. You can't sue for an injunction in small claims court. The other thing is, if this is consumer credit debt, like a credit card, basically, you're limited to suing for $4,000 or less. Besides that, you can take your claim to small claims court. So, Matt,
Yeah, let's talk about starting a small claims court case. Um, the most common reasons to go to small claims court that we hear at Homeline um, are security deposits. And you can imagine that's where a lot of the disputes arise between landlords and tenants. Is after the tenant moves out, the landlord holds the deposit back, and the tenant is not happy with those decisions. And so, filing in small claims court is where it goes. This is not an exhaustive list of all the reasons you can file in small claims court, but security deposits is number one. Privacy violations, that's a reason you can sue. Those rules just changed on the amounts and damages. It used to be $100 per violation. It's been increased to $500 per violation. And that's something you're allowed now to sue in small claims court after you move out. You can say, hey, look, I've got these violations. I'm owed this money. Deposits to hold, that is something that people sue over. This would be money paid to a landlord to, sometimes it's hold the apartment or take it off the market, sort of to keep other people from looking at it. Landlords often charge these fees. There are some very particular rules about when a landlord can withhold that deposit, and if the tenant needs to sue for the deposit, small claims court is where they go. They can sue for an amount equal to the deposit plus 50% penalty, some extra penalty fees. What we're talking about here is not large dollar claims, right? $20,000 is the cap. It is not practical to hire an attorney to go to court over a security deposit claim, even if you're suing for double the deposit, which is the penalty if the landlord sort of is late with returning it. Even double a deposit, we're talking about a couple of $1,000s. Now, that's a lot of money. I would rather have $2,000 than not, obviously, but you're not going to hire an attorney billing at however many dollars an hour to proceed with this claim. And that's why we have small claims court, is that you don't need a lawyer. It's as tenant friendly, not tenant friendly, but as user friendly, I guess I should say, as user friendly a court as you can find. Whether it's tenant friendly or not, that's one that I hear back and forth a lot, but that's not what we're here to talk about. Some
I
other
just want to
claims.
jump in and answer
Yeah.
a question from the chat. Just otherwise I'll lose it.
Yeah.
Sarah Mullins asked, if you pay your rent or security deposit by credit card, are you limited to the $4,000? No, that's $4,000 in debt you owe on the credit card. Basically, that's there to prevent credit card companies from suing people in small claims court over
Yeah.
too much money. So that $4,000 limitation is on debt you owe on a consumer credit account, credit card, store credit, that sort of thing. Sorry to interrupt, Matt, but I just
No,
wanted
that's
to
good.
dispense with that one.
That's a really good clarification. Other common claims would be abandoned property claims. These typically arise after the tenant moves out, but leaves some property in the unit. Landlord has to store it for 28 days, and if it's disposed of too early, there are some additional penalties and damages a tenant can sue for. It's also interesting in small claims court, you can sue for the return of items, like physical items to be returned to you, not just the value of the items. We don't talk about that much. I don't see that case happen a lot, but it's worth noting. Um, Claims that get asked about but are not very successful, that I'm skeptical of their success. Post-tenancy habitability issues, those are sometimes hard to bring. There's certainly an argument here, right? I'm paying $1,000 a month for a place that's in good repair, fit for the use intended, in reasonable repair. The landlord delivered me something less than that, and so I didn't get the value of what I paid, right? These claims aren't always successful post-tenancy. Pain and suffering, we don't see those as successful in contract cases. That is really something reserved for a personal injury or a tort case. And those are complicated to prove, and they just aren't
And you
granted
can
in
sue for
contract cases.
personal injury in small claims court. You
Yes.
absolutely can. We don't advise on personal injury, but when we say that these are claims we're skeptical of, this is how we see it work for tenants in small claims court and from the framework of landlord tenant law.
Yeah.
Just to properly do that. I do want to say, if you have questions and answers, please put them in the specific Q&A box. There's a separate Q&A box from the chat box. We do want to answer your questions, but the Q&A panel lets us keep track of it a little easier because we're trying to provide information down there in the chat too. So it'll let us keep track of your questions and answer them when the time arrives. So thank you. We do appreciate that.
Yeah, mold-based personal injury claims, generally mold-based claims also, very specific types of claims, very specific rules, very specific showings of proof, just beyond what we as a tenant hotline can be knowledgeable about. All right, this is me again.
Yeah.
Starting a conciliation court claim. So let's talk about life cycles. I love talking about life cycles. This is just like biology back in 7th grade again. I love it. I need some arrows though. So it starts when a dispute arises, right? Talking about a security deposit, the tenant moves out, gives a forwarding address. The landlord either sends the letter within 21 days or does not. The tenant disagrees with the deductions. We've got a dispute here, right? We got a problem. I always, pretty much always recommend trying to resolve it before going into court. A lot of times you can talk these problems out. Usually this means a letter, email, text, a phone call, whatever it is, but it's always worth it to try because sending a letter costs 63 cents. That's cheaper and faster than a court case. Maybe it works, maybe it doesn't. If it doesn't work, you're on to filing, and that's filling out the complaint, and that's handling the service of process. You will get a hearing date. Dan just mentioned this. Dan, I'm stealing your thunder. Ramsey County is very backed up on their conciliation court docket. I assume most other counties are as well. When would I expect a hearing if I filed today? 3 months? March? Dan says March.
Well,
I think 3
in
months with a
Ramsey
huge
County,
shrug.
I will
Yeah.
say that the summons are almost always issued 3 months before the hearing. What they're doing right now is not issuing summonses. So if you file today, I don't know, 3 months plus 2 months, February or March, you might get a hearing. Don't let that discourage you. That's still far faster than a full civil case, and those delays are a little unusual.
Yeah. Yep.
That's not how it usually works.
No, things have been in flux. Really, what with COVID and all, coming back and going forward, it's been a mess. So a counterclaim? Oh,
Sorry, and I was going to say that's in Ramsey County specifically, but
yes.
other counties, your mileage may vary.
Yes, exactly. Counterclaim, right? If I'm bringing someone to court, this is their time to bring me to court. It goes both ways, and the other side may file a counterclaim, and ultimately, at the hearing, the judge will decide who's right, who's wrong, and that's the hearing. Prior to the hearing, the court will say, "Have you tried to work this out? Go out in the hallway, or we'll set you in a separate Zoom room. See if you can figure it out." And sometimes that works. If it doesn't, then you go to trial. The trial in small claims court and conciliation court is very fast, and you will get a judgment, and you can decide whether you want to appeal the judgment and ask for removal, essentially, to district court, start all over again in district court, or if you want to proceed to judgment enforcement. And that is the end of the line. That's what you're looking at.
So we're going to get into some of the technical aspects of actually filing a case. So the statement of claim. The statement of claim is the pleading document that starts a conciliation court case. In full civil court, you'd call this a complaint. Statement of the claim, statement of the case. It's pretty much the same thing. The court publishes a template. When you get this presentation, it should have the hyperlink in it. But you can also go on the court's websites like courts.mn.gov and go get forms. All these forms are available. It's a highly prescribed, very user-friendly form. It walks the plaintiff, which is the person suing, through the process of completing it. So to talk about some technical aspects of kind of the most common questions we get. Who are you suing? Well, make sure you're suing the right person or entity. I see a question in the Q&A about an LLC. We're about to address this. Whom are you suing? Are you suing the right defendant and defendants? Are you suing all the right defendants? So just to say, you should sue whomever owns the property or and whoever manages the property. Those are often two separate things. Sometimes they're the same, sometimes they're different. It does not matter whether you're suing an LLC or an actual person. There's some practical stuff there. It's actually kind of easier often to sue LLCs because you can figure out where you send the letter. A lot of times we'll get into this a little bit, I think, but when you're suing a person, you may not have their address, which means you can't really sue them if you don't have their address. Just a practice pointer, do not sue individual employees for conduct that's really attributable to a company. You're not going to get in trouble, but nobody would want to be sued for doing their job, even if they were doing their job poorly. If somebody did something to like assaulted you or did something that is kind of in their personal capacity, then go ahead and sue. But it's just not legally proper to sue somebody who's acting within the scope of their employment. So say there's a property management company and your manager is named Greg, sue the management company. Don't sue Greg, as annoying as he can be. So service in conciliation court cases is almost always done via mail. So you need the correct address for service of process. First of all, your lease is supposed to give you that address. If it's the address in the lease, for the landlord or for the management company, you should be able to use it. The other thing you can do is you can check property records. No matter where you live in the state, if you search your county, like Hennepin County, Stearns County, Crow Wing County assessor, you'll come up with some sort of page. And if you navigate around, you'll be able to find property records, publicly accessible property records that almost all have the address of record for whoever owns the property, whether it's an LLC or a person. They're supposed to have the official address where they want all the tax paperwork sent in there, and you should be able to find it. I've never had a county, I haven't practiced in all 87 counties, but I've never not been able to find. I've always been able to find some kind of property records that indicated who owned the property. Business records. If your management company or the owner of the property is an LLC or some kind of like business entity, great. This is perfect for you because they have to register with the Minnesota Secretary of State, which allows you to search all their business records. They must provide a registered office address, which is an address where they can be served in any lawsuit, but especially served by mail. So that registered office address has to be in Minnesota. And so that registered office address is valid for service in a small claims court case. So I just marked the question as answered. If you have an LLC, great. If your landlord has an LLC, great. Look up the LLC's information and sue the LLC at the registered office address. The remedy. What if the LLC is out of Minnesota? Well, if they're operating in Minnesota, they have to have a Minnesota address. If they are breaking the law, then that's like a whole separate set of things. You could report them to the Secretary of State for operating without a license. Report them to the Attorney General's office for operating in the state without a license. I haven't really seen that happen with smaller entities. So if it does happen, there are other ways you can serve a small claims court case out of state. It's more complicated, and we're not really going to address it within the scope here, but it's not something I've really seen happen. So when you're filling out the statement of claim, you have two options. First of all, you can sue for money. Very straightforward. Somebody owes you money, you can sue them for it. Or if you've suffered damages and you want to sue for whatever damages, it's money. Just one little practice pointer. There are two fields there. There's a field for your damages, and then there's a field for the filing fee and costs. In small claims court, you are entitled to recover your costs of filing and your costs of serving the case. So you can put down your $70 to $80 filing fee and your 63-cent stamp, or if you have to mail it, actually you have to do certified mail, so it's like $4.50 or whatever. And you can put down your $4.50 for certified mail, and you can include that in the statement of claim. In some rare circumstances, there's a property section of the form. This is what we referred to earlier as replevin. Basically, you can sue someone to force them to return your property. Some of my favorite versions of these are when a couple break up and one side keeps the dog and the other side wants the dog. Dogs are property under the law. You can sue for the dog. In the alternative, the judge can just award you the economic value of the dog. These property may be appropriate in an abandoned property case. Again, we don't see those in small claims court that often, but I did want to throw it out there. The next section of the form is the sufficiency of the facts. Basically, there's a part that says, why are you suing? I advise putting less on the form than you think. One brief paragraph explaining why you're suing. My landlord kept my security deposit. They claimed these damages. I disagree. Therefore, I am suing. You do not need to give the life story on the form. I really hate to say it. No one's going to look at it. It's nothing personal. These small claims court judicial officers are moving very quickly, and they are really more interested in what you have to say than what you put down on the paper. So I've seen people write a lot, like 2-3 pages that they attach. I can't say it won't help, but I think it's probably less important than what happens at the hearing. And the thing I always say is add up your damages. Let them understand see your math. Show your work on your math, why you're suing for the amount you're suing. I'm suing for my $1,000 security deposit, plus a $1,000 penalty, plus the $500 in bad faith damages. Judges get tripped up on math. There's a lot of mean jokes about lawyers and math that are extremely rude and often true. So I would say do the math for the judge, make it easy for someone to give you what you want, and there's a chance they'll do it. Matt, you're on to filing.
All right, awesome. Here we go. Yeah, so we're talking about, filing. How do you get the paper to the court to really start the case? You fill it out and then you bring it to the court. And you could do that in a couple different ways. The old-fashioned way was you printed out the paper and you walk it down to the courthouse and here you go and here's the money. But in the year 2024, you can file electronically, and that is the guide and file system. It's really cool. I'm really excited about it, right? This is what gets me excited now, is the guide and file system. Basically, it walks you through step by step the name of the plaintiff, the plaintiff's address, the name of the defendant, defendant's address, what county are we talking about? And each step you fill out, and it makes sure you fill it out relatively correctly. And then you click it and it files. And it's really tremendous. Otherwise, you got to go down to court. You got to look at the architectural wonder of a nearby municipal court building. Look, there's some great courthouses out there. I'll go ahead and say it. Varying from older styles to more modern ones. It's just a great field trip, but not a field trip you need to make, or we all have time to make. Let's be honest. What county to file in, I think, is a good question that pops into my mind. Generally speaking, you're going to file in the county where the rental was located, or the county where the landlord is domiciled, where the landlord is located. Those are sort of, in a way, a plaintiff has some choice of venue in that situation. A lot of times it's the same. They rent in Hennepin County and they're located in Hennepin County. So Hennepin County it is. Court staff, they can be very helpful. Making sure the forms are filled out correctly, making sure you get filed, go to the right window, that sort of thing. Court fees, we're talking about $65 to $80. They're sort of set by the county courthouses, each county individually. Pay cash or certified funds. Some take checks. Again, it's the county by county situation. But filing online, you can go with a credit or debit card for an extra $5 fee. Hey, look, it's really easy to sue somebody in America, right? Doesn't that just get your heart pumping?
I always tell people the online filing system is easier than a lot of e-commerce transactions.
Yes,
it's
I think
very
that's correct.
easy. And it's not on this side, it's on a later slide, but there are fee waivers available for people below a certain income or who receive certain benefits. We're not going to go super deep into fee waivers here, but if you're low income, you can try to apply for a fee waiver. You can also apply for a fee waiver through the online filing process. So we're on to my passion as an attorney, service of process. For people playing the Magna Carta drinking game, this is the second Magna Carta reference. Service is a cornerstone of due process. It goes back to 1215. And really, this is where it comes from in the Magna Carta. I'm not going to read the whole excerpt, but nor will we go upon him or send upon him. And that really is the root of due process. Like, you cannot be sued without notice, not just notice at all, but notice of what you're being sued for and where. Service is an eminently technical process. This is nuts and bolts stuff. And I see a lot of people get tripped up with it, and it's not your fault. I just want to say, if you messed up service of process, I am sorry. It is a little difficult, and it is not clear. The courts do try to provide good instructions. That's another thing to point out. It's not in the presentation. Most counties, when you file a case, will give you a handout, either in person, or if you file online, it'll be part of what is emailed to you. They give you a notice telling you how to do this stuff, some of it. We want to provide that information and some pointers now, because every county does things a little differently. This is the rule that governs service in small claims court. If you are suing for $2,500 or less, the court will do this for you. And this is honestly pretty good. A lot of security deposit claims fall below this. Some of those actions for a deposit or for an application fee probably going to fall below this. Don't sue for less than you're owed just to get the court to put a stamp on an envelope for you. But it is pretty good, because a lot of landlords will claim they didn't get the mail or they didn't get the service. And if they tell a court, oh, we didn't get the mail, and the court's like, actually, we mailed it to you, so you're calling the court a liar. And I've seen that happen, and it doesn't go well. If the claim is for $2,500, if it's for more than $2,500, the plaintiff, the person suing, must serve it. But it only has to be served by certified mail. So that means tracked, right? Sometimes called registered mail. It's the green one. It's the green and white sticker. It costs about $4.50. You can try to recover those costs if you win the case. I know that, for a lot of our clients, spending extra money on the mail is an imposition. The exception here, and this was asked earlier, what if the defendant is totally out of state? You have no in-state address. That's tricky. Honestly, call us about it. If it's landlord-tenant law, we'll try our best to help you. But what it means is you either have to serve them personally according to the law of the state they're in, or you have to serve them by publishing it, which is a big pain and costs money, because you have to literally put an ad in a newspaper, in a specific list of newspapers that's on the Secretary of State's website. It's a really annoying process, probably not worth it for most small claims court cases. But if you have that problem and there's no way around it, no way to find an in-state address, then call us and we'll try to help. Rules. The main rule for service is that the statement of the claim and the summons must be served by mail, and proof of service filed within, and here's your time frame, within 60 days of when it's first issued and within 14 days of the hearing. So I've had people say to me, I want to give my landlord the least amount of notice possible. And I was like, well, here's the time frame you're working with. I advise just do it right away. It doesn't really matter. The defenses are going to be the same whether they have 2 weeks to prepare or 3 months. Again, these are not, federal lawsuits. they are largely determined by testimony and pictures. So again, just to repeat that rule, you must serve and prove service by mail within 60 days of when the summons is issued, and at least 14 days before the date of the hearing. And service is effective on mailing. As long as you do certified mail, it is effective from the day the post office takes it from you. Affidavit of service. This is one of the forms that I think trips people up the most. This is how you prove service. It's not enough that you mail everything to your landlord. You have to prove to the court that you did it. The courts give you a form for this. It's very straightforward. Make sure my pointers here are make sure you tell the court everything you served, because you have to serve both the summons and the statement of claim. And if you only serve one or the other, that's invalid. Case could be dismissed or rescheduled, but probably dismissed. The second thing is if you only tell the court that you served one thing, the case could be registered or dismissed. So make sure you check all the proper forms. The other thing I've seen is that don't just give the court the tracking information. You should give them the tracking information, but you have to actually do the affidavit that says, I swear under the penalty of perjury that I mailed this on this date by, to this person. There is case law that says tracking information alone is not enough. Even if it literally proves service, just giving tracking information is not enough. You have to swear to it under the penalty of perjury. The other thing is the affidavit does not have to go to the landlord. The affidavit only goes to the court. You only have to prove service to the court. That's personal service. Just a note on personal service. Personal service is always acceptable. And that is like you've seen on TV, somebody walking up to you and say, you've been served, and handing you the documents. It has to be done by a third party. So you can't serve your landlord personally. It has to be a third party. They have to swear to it in an affidavit. It is always legally acceptable to personally serve somebody. It's just often impractical or more expensive if you have to pay someone to do it. That's why conciliation court does not require personal service. And we talked about the fee waiver. That's done at the time of filing. Those documents are confidential. They are not visible online if you file for a fee waiver. So you do have to provide personal information, income information, family size, assets. That's not going to be publicly available online. Only the judge is going to see it, the judge and the court's employees. But there are ways to get these fees waived, and even to get the sheriff to do service for you personally. If you qualify for a fee waiver, you qualify for free personal service from the sheriff's office.
Yeah, the sheriff does this stuff. That's part of their routine and part of their like normal duties is service of process. And there are other companies that do this. Every city has their own service of process company or several. And so if you do have an out-of-state landlord who you do have to sue, a quick Google for service of process companies Phoenix probably will turn up something. I don't know what they'll charge, but there'll be something there. And there you go. Okay, so let's move on to settlements. Now you're in court. Now you're talking about settling. We were talking about this before you filed too a little bit. I think settling is interesting. Negotiation is interesting because it involves making decisions and why people make decisions. And so it's a fun sort of thought process for me. There have been a countless number of books about negotiation, about settling, a lot of sort of game theory, right? All these like exciting phrases that we might use about it. But one thing that is certain is that the court does want to encourage people to settle. They encourage people to settle because then people tend to be happier with the results when they have some sort of contribution to the results. Going to trial, you're presenting your case and you're presenting it to the best of your abilities, and they're presenting their case. But in the end, the judge is the one who awards the number, and your involvement is limited. When you settle, when you make a negotiation, you have some more control over it. You're deciding, is this yes or no? Is this something that I want? And that makes it complicated because a settlement is always going to be some form of trade-off. Settling the case can get it done quickly. It can get it done more certainly, right? My dad says, my old man says, and now I say it to my kids, right? We only have three things in this world, right? Time, effort, and money, right? That's all that we have in this world is time, effort, and money. And what is the value, right? What is the value of going to court to get every last dollar if you can get 60% of it 6 months sooner, right? At a certain point, the time value of money, right, sort of catches up with you. And it reduces your risk. If you make a deal with the landlord or the opposing party and they agree to pay you 60% of your claim, then you've got the question marks put out of it. It's not a question of what will the judge say? Will the judge rule for me, or will they rule for them? Or will we both get zeroed out? Or what will it be? Right. So those are good reasons to settle. You know, it's a negotiation. You can ask for whatever you want when you negotiate. The other side is free to turn you down. There's a lot to do with tactics. Who makes the first offer, right? That there's probably 100 books written about that. uh how high do you go? Where, you know, do you leave a little room to go back and forth, right? I think of it as sort of kicking a field goal, where on the one hand you've got a number so high that negotiations are completely shut down, and on the other side you've got, I left a whole bunch of money on the table, so you're looking to get sort of in the middle of these uprights, right? And that's a tough one to know. It's all sort of feel. It's all sort of like, you know, poker metaphors and staring contest metaphors, and it's all really, really hard to predict. But there's pressure. There's going to be a lot of pressure to settle. And sometimes a letter offering settlement before you file could be successful. And if it is, that's great. You've got it done in a letter, and 14 days, the dispute is over, right? Maybe that's how long it takes. If you have to file, well, 3 months until you get a summons issued. 3 months after that, we're here in, you know, March. Now we're in court. And at court, when you're settling in the hallway, when you're in the Zoom room, there's a lot of pressure. It's a pressure cooker in there because the judge is on the other side of the door, and maybe the judge already seemed a little cranky, and now you've got a lawyer on the other side. And I'll be honest with you, a lot of lawyers, they're jerks, man. I don't know. It's something about the profession. Um, People probably say that about me. I'm sure they say it about you, Dan. I don't know.
Oh, all the time.
All the time. All the
That's why they
time.
call me Dealin' Dan.
That's right. So they can be forceful, right? The other side can be forceful and belligerent. And you have to know going in, what am I willing to walk away with here, right? Because it is a pressure cooker. And when you make a deal, that's it. It is done. It is almost impossible to unwind a settlement agreement once it's made. Um, and that's it. That's all I have to say about unwinding a settlement agreement. It is basically impossible.
I've seen it happen
You don't,
once. Once.
there you go. Once. Yeah. Um, you don't have an obligation to settle. The court will put you in the hallway. They might put you in a small little room. There might be a mediator even.
They might send you
But you,
back.
yeah, they
You can
might send
come
you
in, they'll
back.
send you back. They'll say, go try again.
Yeah, that's right. But you don't have an obligation. You've always got the right to have your claim heard in court. You always have the option to, yeah, roll the dice and see how they go, right? Again, another gambling metaphor. That's not really helpful. But you've always got the option to say, no, I want my claims heard and I want the judge to rule on it. And that's important to know, because just the appearance of willing to go to court is sometimes enough pressure on the other side to get them to come down from their number a little bit, right? Now we're getting into tactics. Now we're getting into strategy a little bit more. That isn't really the idea here. But settlement is a complicated process. It's a fascinating process to me.
It's a quick moving
Yeah.
process, usually.
It's a quick moving process. Sometimes buyer's remorse is involved. That's something that happens.
When it comes to figuring out your number, this is like, people always say, what should I ask for? I was like, think about the least amount of money that you'd walk away for. That should be your bottom dollar. And don't offer your bottom dollar, but
Never.
Know what in economics, we call this your reserve price. Know exactly what the least amount of money, where does your supply and demand curve meet? What's the least amount of money you're willing to walk away for? And think about the amount that would make you happy. And like, yeah, that's the full amount, but reasonably try to be like, okay, say I didn't get everything. What's the amount where I'm still like, yeah, I beat that guy?
Yeah.
You know? And just one last note, nothing you say in a settlement negotiation can be used as evidence against you or for you even. So if the landlord says like, oh, we know we screwed you over, if he said it in settlement negotiations, it's not admissible in court. The judge will ignore it.
Court is hard, right? We talk about court a lot. We have experience in court, but not everybody does. And going to court can take a toll. Some people, they just don't care. They sleep fine with court. This conflict is no problem for them. But for a lot of people, the prospect of going to court, the prospect of filing something in a courthouse, upsets the stomach, keeps you up at night. You can't eat, right? You can't think about anything else, and it just weighs heavily on the mind, right? And all of those factors have to go into your decision of should I settle or should I not? What is it worth it to me to get this case over with? And that's what makes it so interesting. Is that there's a lot of like, I don't know, it's like you have to, when you settle, when you make a decision like this, I don't think there's a wrong decision. You're making the decision for you that's in your best interest. And someone else might say, oh, it's an awful small number you got. But no, the number that you decide is right for you is the one that's right for you. And there's no wrong answer there.
Somebody asked me to say, repeat something. Settlement negotiations are not evidence. They cannot be admitted into evidence. So if the landlord says something to you in a settlement negotiation, you can't then go use it in court later. That's
and vice versa.
And vice versa. You can
Yeah.
say, I don't think I have a strong case. They shouldn't take that to the court, and the court should ignore it.
Yeah. I think these are a lot of recaps of what I talked about, settling before filing. It's quick, right? It's cheap, and there's a certainty. There's a lot of uncertainty that goes with filing a case, and sometimes it's just hard to deal with on a personal level. Certainly during the case, after it's been filed, you can make a settlement offer at any time. At any time, it's fair game to make a deal. After filing, everybody's on the clock. A hearing is coming up. That's time, effort, and money out of everybody's sort of pocket, literal and metaphorical. And in the hallway at the courthouse, it's a pressure cooker. Everything is just as uncertain. We still don't know how the judge on the other side of the door is going to rule on our case. But now it's even more immediate because it's showtime in 5 minutes if we can't make a deal. Okay. But post judgment, after the judgment, you can still settle. We're going to talk about some of the work that comes with collecting a judgment. And sometimes it's worth it to take a discount just to get paid even after you won, because things can always go wrong. And money now is worth something.
I would never. I like enforcing judgments too much. I would never settle after. But if my client wanted to, I would allow it. That's a Mattism, and it's probably smart. It's there. Your time has value. Matt pointed that out earlier. Your time and your effort and your stress levels all have value. If you can get the landlord to write you a check today, I would take a discount. So, just some issues after you filed the case, but before it's been heard. Counterclaims. People always ask, well, if I sue the landlord, can they sue me back? Yeah, they can. They can file a counterclaim in the same case. Basically, a counterclaim, they can assert any counterclaim against you. Say you sue for the deposit and it's $1,000. The landlord says, well, they actually did $3,000 worth of damages. The landlord has the right to sue you for that $3,000. Sometimes tenants say, well, if I go file, is he going to ask for a counterclaim in response? Maybe he was going to sue you and that gave him the opportunity. Maybe it doesn't. I can't tell you because I don't know your landlord. I can tell you I don't see a lot of counterclaims. Even where landlords allege that the tenant owes them money, I don't see that many. They happen. I couldn't put a percentage on it, but a minority of cases. Really the court wants to hear everything at once. They don't want you to file one case, then come back 6 months later with another one. If the landlord files a counterclaim, this is a real dispute. It's actually a huge imbalance in the law right now, but basically a landlord only has to file a counterclaim 7 days before the hearing, and there's no service requirement in the law. So they can file it and show up and be like, hey, guess what? I asserted a counterclaim. I think from a policy idea standpoint, the idea is that really, if a tenant is suing a landlord, the tenant should know what the landlord's going to say in response. We know that's not always true. If there's a counterclaim and you need more time to prepare, ask for a continuance. Do it in writing, file a letter into the docket, or call the court, and you can ask for a continuance. I've never seen a continuance in a small claims court case denied. Even when it's very shortly before the hearing. Try to do it a couple days before the hearing. Courts will appreciate that. They will happily pay you for a hamburger today, tomorrow, or whatever the Popeye saying is. They love continuances. Evidence. We get so many questions about evidence in small claims court. What's the evidentiary standard? None whatsoever. There is no standard. The rules of evidence do not apply in small claims court. A small claims court judge can enforce them if they want, but they really don't. They're not that strict. What they really want to do is make a fast, kind of fair decision based on the information in front of them. There was a question in there about who has to provide evidence. What? Davina asked that. Evidentiary exchange. You do not have access to discovery, so you can't force your landlord to give you any information. But if either side wants to use information, a judge will almost always set a schedule for when information has to be exchanged. In my experience, it's almost always 1 week before the hearing. It'll be in the summons almost always. It'll say you must email it to the court or drop hard copies off with the court and to the landlord within 7 days of the hearing. So if you do have one of the rare in-person hearings, make 3 copies, one for you, one for the judge, and one for the other side. If you are exchanging evidence online, you have to give the exact evidence you want to use to both the court and the landlord. It has to be the exact same thing. I get a lot of questions about, can I use this as evidence? And my answer is like, yeah, everything's evidence if it's relevant. I would just say more evidence is not always better. From a practical standpoint, focus on what actually proves your claim and keep it short. Don't give the landlord 200 photos. Give them the 20 most important photos. Give them the 5 most important photos. And the other thing people say is, oh, I don't have photos. I didn't get photos of when I moved out, etc. It's not a silver bullet for your case. Most of these cases are decided just as much based on testimony as they are photos. I think CSI has trained people to think that they need DNA and forensic evidence and heat cameras and all this crazy documentary evidence, and you don't. I would say a ton of cases, especially in small claims court, are decided based on testimony. And I always tell people, testify credibly, tell the truth. Number 1, that's your obligation. But 2, don't, if something doesn't favor you, say, yeah, I wasn't perfect. I left a little mess, but I didn't leave $2,000 worth of mess. And testify credibly. That's really, really important, is credible. So let me go to the next. So we're gonna tag team these slides, these points. You're preparing for your hearing.
All the world's a stage. You you know your lines, right? You know why you're there. You know what your grievance is. You've written it down on the filing. You've told your family and your friends a bunch of times. You've told them how this landlord ripped you off, right? Now it's time to present that to the judge. And so I don't like to say that, oh yeah, this is just like a play or something, but you do know your lines. You know what you're going to say, and you sort of know what they're going to say. In the case of a security deposit case, the landlord has sent you a letter saying, here's why I'm keeping your deposit. We did 30 hours of cleaning on your apartment. You know what your response to that is going to be. And so rehearse it. It sounds silly, but say it in front of a mirror, right? Have some friends sit on the couch and stand up, like actually stand up in front of them and say it several times and go through your case, because you want to be comfortable saying what you're going to say. Going to court is a very nervous experience. I think about courtrooms, and sometimes I think they're set up in a way to make people feel nervous, right? You have to walk down this aisle and you have to go through this gate, and the judge is sitting like way up high, right? Like
You have to take
the
your belt
lawyer,
off now.
you have to take your belt off now. Nobody likes
It's like
that,
an
right?
airport.
Yeah. And
Shoes
you
on,
time
belt
on,
off.
yeah, time of day, and you've been up thinking about it all night and all this stuff, right? And rehearsal and practice is what's going to make it go smoothly and make you feel comfortable. And so I do say, all the world's a stage. Know your part
And
and know your lines.
Matt hit most of that. The only thing I'd rather say is take notes. Write yourself a bullet point. Write down your key points, the things you want to say. And point out where the evidence ties into that, because this is what will help the judge rule for you the best. Not just what you say, but tie it directly
Yeah.
to a great photo of a clean wall, etc.
They said
They
8 hours of cleaning in the kitchen, Your Honor. Here's the kitchen.
Rachel just said
And you can do this.
they made me take my shoes off going through security in Hennepin County. Experiences can differ. That hasn't happened to me, but it could be. Give yourself time. If you are going to a courthouse, Rachel's point brings up a very good point. Give yourself, you not want to be late to your hearing.
Yeah.
As far as the hearing goes, time is not on your side. People say, how much time do I have? And I said, well, these are big calendars. They're sending people off to negotiate, bringing people back in. They have one afternoon to do. What did Steve say? 20, 30 cases sometimes?
Sometimes, yeah.
I tell people you will have 15 to 20 minutes maximum for your side of the case, probably more like 5 to 10. They're going to make you negotiate first. We've talked a bunch about that, but be prepared. Like, some people are like, I've learned my lines and I'm ready to go. And then it's like, sorry, you got to improv first. You're going to have to go negotiate. Matt says it's like Judge Judy, but less shouting and fewer wisecracks. Do you want to
That's right.
elaborate?
Yeah, yeah. This isn't formal court like you'll see like district court. We'll talk about district court where the rules of evidence and the rules of procedure and submitting things to evidence in all these like very formal and specific ways apply. This is more like Judge Judy, where the judge says, plaintiff, you filed, what's your case? There's fewer shouting, fewer wisecracks, as we all love Judge Judy for. But that's really it, is that it's a lot more informal. It's really you telling your story.
There is a question I want to address. Yolanda asks, if we represent ourselves, are we able to ask landlords any question we want? If in a full civil case, for sure. Small claims court case, maybe. The judges do not have to follow strict rules of procedure. The judge may allow you to ask the landlord questions. They may take a stronger hand. And a lot of small claims court judges, most in my experience, will play the middleman, ask questions of both sides. If you have something you really want your landlord to bring up, ask the judge. Be like, that's my question for the landlord. And the landlord may turn around and ask it to the landlord. Some judges will let you examine the landlord, or I just can't tell you exactly because we have a lot of conciliation court referees. They're called referees. I've been saying judges. They're not full judges usually. They are attorneys who are deputized to act as judges. So referees, judicial officers, hearings officers. If I say small claims court judge, it's all referring to the same type of person. So
They
sorry for
wear a
that
robe.
aside.
They wear a robe and they have a hammer, and to a certain extent, that's what a judge is about. But as far as court, it's as user friendly as court gets, and this is still an intimidating process, and so it feels a little disingenuous to say it's user friendly, but it's as user friendly as it gets. Know your story, know what you're going to say in advance, and know the phrase that pays. I will say a line and you will finish it in your head. If the glove doesn't fit, you must
Must
acquit.
acquit. Yeah, the
Must
greatest
acquit.
piece of trial lawyering of all time. But
That's the phrase that pays.
yeah, so find your glove.
Yeah.
It's important. That probably saying something that sums up your case and sticks in the judge's mind in 20 words or less is the number one thing you can do to win your case.
Yep. And if you circle back to it a couple times, good. Good.
So we're gonna speed through this. What happens if things don't go your way? What if you miss your hearing? Car broke down, a tree fell through your roof, and your internet crashed. If you miss your own hearing, you have 24 days to file a motion to vacate the judgment, because judgment will be issued against you. You can vacate that judgment. These motions to vacate within 24 days are almost always granted. It would have to be, a court would have to somehow believe that you were cheating on the court. Like if you were, if you logged into the Zoom room and then pretended no audio was coming through and then disconnected, like, sorry, breaking up, like, then they might hold it against you. But even then, probably not. After 24 days have elapsed, then only the defendant, the person being sued, can move to vacate. The idea is that if you're the plaintiff and you miss your hearing, you wanted that hearing and you should know you missed it. A lot of times defendants don't know that there was a hearing. It just happens. Sometimes it truly, everyone can be doing everything right and they can just not get notice. There is a process in place for that. We're not going to dig too deep into it here because it's relatively rare. Say you sue and you win, you lose. You sued your landlord for $5,000 and you got nothing. You got $0. In fact, the court ruled against you for $5,000. You have the right to an appeal. Every small claims court, conciliation court case, you have the right to take it to district court and start over again from scratch. That's full civil court, though. The rules of civil procedure apply, the rules of evidence apply, and you have to complete that appeal within 24 days of the judgment. I can't tell you if your appeal is right to you. Yolanda just asked, can you request legal fees you paid if you win? Filing fees, yes. Attorney's fees, it very much depends. Just because I don't think we're probably coming back to remedies unless we wait all the way to the end. But you have 24 days to file an appeal. If you're a tenant and you have a question about whether an appeal is viable or whether it's practical, call us and we'll talk through it. I will say that these civil cases, even when they're put on an accelerated trial track, which is often what happens, 9 months, a year, 15 months, year and a half, depends. Depends on what kind of motions are filed. Depends if your landlord lawyers up and drags out the case. Not to say you shouldn't appeal if you want to vindicate your claim, but it's very different playing field. I've provided the steps for appealing. Not going to dig into that too much here. It's a very technical but straightforward process. It does cost about $300 to $400 to appeal. And should you have the right to request a jury? Should you or not? I don't know. I don't know your case. Let's talk about it. If you want advice on whether to seek a jury trial or not, you do have to pay an extra fee for a jury, and there's a lot more complications with juries. But it might be right for your case. It might not. If you have questions, please call us.
All right,
Matt?
let's talk about. We think we're very funny. I just want to say that we think we're hilarious. All right. So how to collect when you're collecting? First, you have to wait the appeal period. Right, nothing can happen in that appeal period. Everybody gets that chance to decide: do I want my do-over? Right, my de novo review. Sometimes the other side will pay up because they know they lost, they know they're not appealing, and they just don't want to deal with this anymore. And so you get a check in the mail, and ta-da, it's done. But that's not always the case. There are certainly some people who make it a sport to avoid paying anything and being collected from, and that's that's where judgment collection comes in. If there are some doubts about collectability, at a certain point, a person is on a judgment proof is what we would call it. You can't get blood from a stone. And if the person doesn't have any money, if their only income is from, say, Social Security, if they receive public assistance of some sort, they are very difficult to collect from. And someone might declare bankruptcy. That's tough to collect from, right? So that's sort of a post-judgment reason to maybe negotiate, maybe. But again, the amount we're talking about here is very dependent upon, look, you've won. So how much of a discount should I give? If nothing is filed, no motion to vacate is filed, then you can start. It is a slow and legal process. It's slow but steady. Now it's just about forms, though, right? The track is laid down on iron rails, and it's just a matter of following it.
Yeah, I will say the court administrators, honestly, this is such a prescribed process that a lot of it is in the hands of civil staff, of administrators, and it can be very frustrating. I'll say I've had people like win their case, win huge, and get really discouraged in the judgment collection process because they got something rejected like 3 times because the court was like, fill it out differently. You didn't include this thing. And if you're a tenant, we're happy to help. A lot of times it comes down to like finding the names or addresses. And honestly, I kind of love that part. You just want to provide the roadmap of judgment enforcement. This incredibly crude diagram will show basically once you have a judgment and the appeal period has passed, you can force the landlord to disclose their financial information to you. What bank accounts do they have? What assets do they have? What's there in the retirement account? How many trucks do they own? Is F-150, F-250, F-350? All sorts of stuff. You can, and it really is fairly invasive, to be honest. A lot of times when they get that order from the court saying, hey, give all your bank account numbers to the person who sued you. That's when they pay up a lot of times. Sometimes they don't pay up. Sometimes they disclose, but say, hey, chase me. And you can get a garnishment. You can garnish their wages. You can levy their bank accounts. If they did pay you, you got to tell the court. You got to say, hey, they owed me 1,000. I got 1,000. That closes out the case. If you get partial payment, you got to tell the court you got partial payment and keep trying to collect. Now, if the landlord blows you off altogether and doesn't disclose anything, you can get the court to do an order for show cause, which is basically everything is court ordered at this point. You are filing forms with the court to say, hey, court, tell the landlord to do this. And if the landlord doesn't do something, you can tell the court, and the court will say, hey, why didn't you do that? That's kind of like your mom coming in and say, why didn't you take out the trash like I told you to? And nobody wants to be caught like that. And the thing about show cause is if you don't give a good reason why you disobeyed a court order, they're going to put a warrant out for your arrest. And used to be in person, they might arrest you on the spot. These hearings are not really done in person anymore. They're all basically all on Zoom. So you get a bench warrant out for your arrest. And the only way to clear that warrant is to complete the disclosure. So I always tell people, they say, is the sheriff going to go arrest them right now? And the answer is probably not, unless they really hate the guy. You can ask the sheriff to go do it, but they probably won't. But the next time they get pulled over on a traffic stop, the next time they come to the courthouse, frankly, there's a bench warrant out. If they get identified by a police officer or some law enforcement officer, they'll probably be arrested. And they won't be let out of jail until they clear the contempt by completing the disclosure form. I just want to provide a quick aside on federal collections law. I do get this question every once in a while. Yolanda, yes, it is contempt of court. The federal law does govern the conduct of debt collectors. These are federal laws with some fairly hefty penalties involved. That said, this does not apply to you if you are just a regular person. And I mean regular as a compliment. But if you're just a person who sued and you won some money, you are not a debt collector under the law. So I have this here to say this doesn't really apply to you. If you are collecting on your own debt, federal debt collection law does not apply to you. I would still advise to conduct yourself within like the realm of reason on this stuff. I've had people be like, I'm going to show up to my landlord's job. I'm going to show up to their house. I would just advise not to do that. Go through the court process. So we're not going to go too deep into this. These are the literal forms you have to file. They're pretty cheap. You can collect all of them back, any of the funds back. You'll see in there, you'll see affidavit of increased costs. Anything you spend in collections on filing costs or mailing costs or service costs, you can add to the amount you have to collect. All of it's pretty simple. It wouldn't be a good use of time to step through the forms one by one here. If you win a debt against your landlord, call us. Happy to walk you through it. And sometimes there can be differences depending. If you are to the point where you have their bank account information or you have their employer information, and you're about to file one of those, please call us. Again, we only serve tenants. These webinars are open to everybody, but for our actual direct services, those are only for tenants. But if you win a judgment, please call us. We'd love to help. So now we're going to talk about some exigencies, like what could go wrong.
what
Well,
could go wrong? Yeah.
anything.
I guess this is also I always like to make a little sales pitch for paying by check when it comes to finding out banking information. You pay by check, the landlord endorses it and cashes it at their bank, and you can get a copy of that check back. And what will be on the back of it is the banking and routing information of what account the money was put into. And so, should you need to levy the landlord's bank account, well, now you've got those numbers. You don't have to fill out the notice for disclosure because you already know them. So, what can go wrong? Bankruptcy. This is a debt. It can be included in a bankruptcy, and the bankruptcy court can put a hold on all collection actions. The bankruptcy court can say you'll get pennies on the dollar of any judgment owed. That's a problem. You're not going to get paid, not like you should. You can't find their assets. Some people, they just live a strictly cash lifestyle, right? And like I say, they make it a sport. Death of a debtor, it's a problem. um, maybe you got a
Probate
claim
court.
against, yeah, maybe you got a claim against the estate, right? um but yeah, you're in probate court. Yeah.
If there are exemptions, we talked about being hard to collect on earlier. Maybe this is landlord, maybe not, but they may qualify for exemptions. It's possible. They may be low income, they may be disabled, they may have protected funds. Recently, our legislature expanded these categories of collections. This is overall a good thing for our clients because, frankly, our clients are lower income than most landlords. But it is possible that certain assets and certain income may be protected when it wasn't in the past. Honestly, it's up to the landlord to challenge that. You sue and you start collecting, then the landlord has to challenge it as exempt. So this isn't something I would tell a client to worry about going in. Uh, it's frankly the landlord's duty to respond. And the forms are like a nastier version of a tax return. So, and people hate their taxes. They may not bother. Um, Total refusal to comply. These are my favorite. A lot of people, it's F you and F the horse you rode in on. They're just not going to pay. And that's why the courts can threaten people with arrest, and why they can issue warrants. It may just take some time. You know, revenge is a dish best served cold. The money still spends if it takes you 3 to 4 months to get it. I know it's a pain, but it's still worth the effort, even if you think the landlord will totally refuse. I hear it all the time. My landlord will never pay. A judgment changes things.
Yep. It does. Just having an open judgment on your record makes it harder to get a loan, if not impossible. It makes it harder to sell a home. It's not exactly a lien. A lien is a claim that you can attach to the title of a property, and really talking about like forcing the sale of property in order to be compensated. It's not exactly that, but it's close.
A judgment being in the county, once a judgment is issued in that county and you docket it, basically you make the judgment official. It is effectively a form of lien on all the landlord's like property, like real estate, all their real property in the county that it's in. And you can move it to whatever county you want. You can docket it in foreign counties. Foreign being, for me, Ramsey County next door. I live in Hennepin County. But it is, so it's not quite a lien, like Matt said, but it's also kind of a lien.
It really puts you in a real position where the landlord may be trying to get a car loan and say, hey, I can't get a loan because of the judgment. Well, payment in full. How about that?
So Matt, can you levy against the equity in a landlord's property?
I think there is a method to do it, but it has to be a considerable amount of equity in the home before you can levy against it. And it's a pretty hardcore way to go about collecting a debt, and I think it wouldn't get that far. But the law allows for a lot of different ways to collect, and it sort of becomes a game again. Maybe it's a game that sort of appeals to sort of the dark side of the lawyer, right? Like,
We've all dreamed about being a leg breaker,
yeah, like maybe
have we?
it's not so good to get too deep into it, right? The debt collection stares back at us. But you have other options for collections, right? You
Hey,
can
can I seize my landlord's truck? I talked to he's got a nice F-150. Can I seize that?
you have to have two cars. If the debtor has two cars, then you can seize one of them, and it's sort of up to you or the sheriff doing the seizing to decide which car to seize. And yeah, maybe, yeah.
What about a commercial
Um,
radio antenna?
I heard this story happened with KFAI. I think it was KFAI is that they ran into some problems and a creditor essentially attached to the antenna and unplugged it and put a lock on it. And they crowdsourced the money to get it unlocked. Maybe it was a different station. I can't recall. So apologies to KFAI, but that's what I remember hearing. Um, can you have them arrested? But the order for show cause is sort of like being arrested, sent to Australia. Probably not.
Probably
Almost
not.
certainly not. We don't do that exactly. And
This
then
is
I
an
just sort
open
of
question
brainstormed.
of law.
This is an open question. Probably you can't garnish their prison commissary account. I was just sort of spitballing, as you go for a walk or, whatever it is you do when you let your mind wander. I think they would, I doubt it. I
Here's one of the
seriously
most
doubt
fun
it.
questions. Here, can you intercept your landlord's rent? The answer is undeniably yes. You
Yeah.
can levy any source of recurring income, not just wages. You can go after any. So here's the thing: if your landlord isn't going to give you his bank account, or he does everything's in cash, he's like, I got $8 to my name, just enough to keep the account open. Well, he's probably going to rent out the house you lived in. So have the sheriff deliver the documents there. That tenant is obligated to send that rent every month to the sheriff instead, and the sheriff will send it to you. That's a little bit of a complicated process. If you are going to intercept rents for your landlord, please call me. Please,
Yeah.
please do it.
This
I would
is
love to do
really
it. I would love to help you.
this is really a technique where if you know the tenant also, right, you're friends with a neighbor who's also, because it is sort of shocking to have the sheriff say, nope, don't pay your landlord, pay me instead. There's a lot of disbelief that happens. Yeah,
So that's it.
we're great. Yeah.
Yeah.
Rachel, I know you usually DJ the questions. Would you mind if I just grabbed a few right off the bat?
Have at, I know, oh, sorry, I just froze up there. Have at, we'll get through as many as we can. We have about 13 minutes left. If you two want to stay on a little bit later, if you can, that's great. We'll have the full recording up on our website in a few days. And yes, the slides are going to be part of that in a PDF format.
And we know we talk very quickly. I'm very sorry. Yolanda asks, the judgment to force someone to pay, can it be moved to a different county? Yes. You can put your judgment in any county in the United States. There's different rules for everyone. I can only do it in Minnesota because I only know how to do it in Minnesota. But you can move that judgment anywhere you want. What if the car is in a trust fund? Then you can't take it, right? It depends. Trusts are complicated. If the car is being used for the person's benefit, maybe. It's very specific when it comes to trusts. About appeals. So you can't appeal to federal court. Actually, you can take your case to federal court if it meets certain requirements. It has to meet federal diversity jurisdiction, which is the two people have to be in different states, and it has to be like $75,000 more. I don't know. I passed the bar. Federal civil procedure. There are ways to take this to federal court. It's probably not advisable.
It gets to a practicality issue is that it's 75 to go to county court. And I mean, look, I love the idea of going to federal court. I love the notion of it. It's just a fascinating idea to think about.
And as far as federal courts go, you are taking a 6-month proposition and turning it into a 6-year proposition.
Yeah.
As far as the Supreme Court, there's like a famous case that went from a traffic court to the Supreme Court. So I can't say never. It would have to be a very specific question about the US Constitution. If somehow a small claims court case involved your constitutional rights or the landlord's constitutional rights, I'm a nerd. I'd love to see one of those go to the US Supreme Court. I don't think it's likely, but it is not legally impossible.
It's also, I think, important to point out that the Supreme Court has the final decision about what cases they hear as well.
Yes, that's true. They can deny the case. In the chat, somebody says, I thought landlords weren't allowed to have a lawyer represent them in conciliation court. This is a common misconception. The rule is that a judge may allow an attorney to represent a party to the extent that they deem it helpful. I have seen with mine own 2 eyes a judge tell an attorney to stop talking and stop participating in the case. I've seen it. It's exactly the lawyer all the housing attorneys are thinking of. I'm not going to say his name. On the other hand, I've seen a lot of attorneys do small claims court cases. It's up to the judge. You can have an attorney, the landlord can have an attorney, or you can try, you can both try. The judge may say, I don't want to hear from attorneys. I want to talk to the real people. That's the thing about small claims court.
If
Somebody
you're an
asked,
attorney interested in being a judge in small claims court, they, I think, are very desperate for people to be referees. And so that's an interesting thing to do. But you'll get some stories. Yeah.
5 years of experience, I think, is pretty much the requirement. Um, a, so if a landlord loses and they pay right away, they pay the court and the court sends the plaintiff the money. Not really. They are supposed to pay they're supposed to pay you directly. Courts might accept the escrowed funds and release the escrowed funds, but that's just very rare. Typically, they pay you, and you tell the court that you were paid. What if it's a current ongoing case in what county? Can you move it to a new county to avoid corrupt judges in that county? No. You have to have venue. The only appropriate venues for these cases are one, where the house was, where you lived. For example, if it's a security deposit case, the county of the property in question, or two, where the landlord is located. I won't necessarily say lives because sometimes they're corporations. Ongoing cases, you're kind of stuck with your county. We're just talking about where the judgment can go once you've won the judgment. What will and won't be considered income by HUD? That's kind of outside the scope of what we're doing. Please contact us separately. I see a bunch of questions about HUD and discrimination cases. That's just not the subject matter of what we're dealing with here today. Please contact us. There are federal regulations that govern all these things, including income calculations. Reach out to our hotline or email an attorney service. We would love to talk about that there. So Rachel, I grabbed as much as I could. If you want to start cherry picking.
Sure. Why don't you flip it to the next slide just so that folks can get that phone number and that email again, just so it's on there. All right, so I'm going to start with what's at the top here. And so we're going to go through these. Some of these are going to be more person specific. So if it is your specific situation, again, we highly recommend, and we may just tell you, look, you need to call us because your specific situation, your specific set of facts, we want to give you specific advice. Yes.
Somebody asked a question in the chat about statute of limitations. Just to grab that, it depends on the claim. So in general, most landlord tenant issues are based on a contract, and there's a 6-year statute of limitations for contracts. If there's a penalty involved, it's only 2 years for the penalty. So if you want to sue for a penalty, you have to do it within 2 years. If it's damages under a contract, like a lease, you have up to 6 years. Sorry.
Okay. You're fine. You're just, I need an extra set of eyes always to keep an eye on the chat, you know. So if you want to come hang out with me one Wednesday a month every month, that'd be fine. All right, so Alyssa, you have a bunch of questions about more personal injury when it comes to medical issues like that. Definitely, I think talking to a personal injury attorney about things like medical things resulting from black mold exposure or anything like that, that's well outside the scope of what Homeland can advise on. So definitely, you know, if you got questions about retaliation, however, you know, landlord giving you retaliation is a issue that, you know, if landlord negatively impacts your tenancy after you as a tenant have exerted your rights, and you know, call us, we can talk about like specific rights that you may have as a tenant, then there is potentially a retaliation defense that you can raise, and that tends to be very fact specific. So give us a call, send us an email. We can dive deeply into that with you. So I see as well, Yolanda has questions about taking HUD to small claims court. How do you sue the government, y'all?
Service on they have to have people designated for service. You can sue HUD in small claims court. I would say it depends what your chances of success. I'll say this: you can file any lawsuit against anyone at any time. The question is, are you going to win? It depends on what your claims against HUD are. You know, I don't think that there's a penalty clause in VAWA. Can you force a landlord to spray for bed bugs? Those are kind of separate issues. They're not for small claims court, really, I would say. But you can sue the government in small claims court. I've seen it. There's nothing legally invalid about suing the government in small claims court. It's really about what you're suing them for.
Whether that's HUD or the city or, but if they're the appropriate party, then they're the appropriate party.
And I do just, Yolanda has a second question that is discrimination related, and I do want to just address it because it has a statute of limitations involved. You do have to make a report to HUD for discrimination claim. You have to make a report to HUD or the Minnesota Department of Human Rights within 1 year of the discrimination occurring. I don't want to dig too deeply into it, but just because one of the number one ways attorneys lose their license is by not telling people about statute of limitations. You have 1 year to report it to HUD, and you must report discrimination to HUD or the Minnesota Department of Human Rights before suing. For discrimination, not for other issues, but for discrimination, you have 1 year to report it, and you must report it to HUD or MDHR before suing.
All right. There. I just put links to both of those sites in the chat there. Leases. Tamara, you had a question about allegedly forged leases or incomplete contracts. I think that's a very specific question you should definitely call us about, and we will chat. Sounds like a messy situation for sure. So what I'm gonna, Lana's got a question. You kind of went into this a little bit before, but can you elaborate a little bit more about, say it has been 3 years, right? And you're just suing for your security deposit or something like that. Dan, we can still see your screen.
Sorry about that.
It's all good. So what happens when you don't have the information? What happens if you don't have access to some of the things that you would like to have, but it's been 3 years and you want your security deposit back?
So you can sue without your lease. It really doesn't affect your legal claims. It may just be harder to prove what your deposit was. But there's probably lots of collateral evidence that proves that you lived there, proves when you moved in, may prove what your deposit was. You may have banking records, you may have a money order receipt. If you're having trouble locating your landlord or who managed the property, check your email. I always say there's a surprising amount of information in your email inbox. And just try to do that research we talked about. Figure out who owns the property. At the end of the day, you can always sue whoever owns the property or who owned the property if it's been sold. But at the end of the day, you can always sue who owned the property, even if you never talked to the guy once. We see this a lot with single family home rentals where the tenant may never talk to the person who owns the house. Yeah, you can still sue them. They're still your landlord.
Yep. All right. I love this question, Lana. Are landlords concerned about having a record against them if they lose a court case?
They should be.
So one of
They're
the
really
things that
not.
we encourage folks to do, especially when you're looking for rentals, is do a record search. Your potential landlord's doing a record search on you. Do a record search on them. See how many times someone sued them for security deposit. See how many times they've had a rent escrow filed against them. Do a background check on them. Make sure this is a person that you would want to do business with. So, but the short answer is not as worried probably as they should be or could be. Now, do you two have anything to add to that, Snark?
I completely agree with you. I think tenants should be concerned. If you see your landlord getting sued a lot, chances are they're not just some innocent little lamb in the woods who's being victimized by a lot of big mean tenants. Probably doing a lot of stuff wrong.
Yeah.
Would be my guess.
Yeah. And obviously, realistically, larger landlords are going to have more claims against them just anyway. But, it is something to look into. And it's free. You can do that on the Minnesota Court Records website. Oops, that is not all right. So Tamara, you said verbal written notice regarding deposit. So the landlord just ghosts you on your deposit after you leave. They haven't been complying with what the statute requires, and you can look into filing a small claims court claim. So John, I know that you had said, how do I file for a counterclaim? We included the link in the chat for some of those forms, and we kind of went through that. But Matt or Dan, you want to be really quick? Just recap.
It basically looks like the statement of claim. You'd have to know you're being sued in small claims court. And once you know, you can file the form. As long as you file it a week before the hearing, you're good. It's pretty straightforward. It looks exactly like the statement of claim, essentially.
Yep. There's a little line that says case number because there's already been a case number, and that's pretty much the difference.
Yep. Tamara has a related question. Oh, if the counterclaim is over 2,500, do they need to send us evidence and provide service of process? So that's like if you're filing the claim and then the defendant is counterclaiming against you.
So the amount in question does not affect evidence or the need to be served in some way. If the claim is that the only difference with the 2,500 is who does the service. If it's 2,500 or under, the court does service. If it's over 2,500, the person suing has to do the service. Again, the amount in question has nothing, that doesn't change the evidentiary requirements. A judge is probably not going to award $20,000 based on no kind of documentary evidence. The evidence is really, it's up to the judge. What does the judge say? If the judge says you have to use you have to give any evidence you want to use within a week, that's the rule. The judge can also allow in evidence if he wants. For example, say you found evidence the day of the hearing that proves your case entirely. In regular civil case, maybe there'd be exceptions, but probably not admissible under most circumstances. You might have to provide more notice, reschedule, whatever. In small claims court, they could say, oh yeah, their job in small claims court is really to do what seems fair more than strictly follow the law.
Because most of the time the law doesn't get that nitty gritty. So, all right. Anonymous. I don't quite understand the terminology you're using about a case being recalled if the mediation between manager and regional manager didn't go the way you wanted. If you want to rephrase that potentially, or if the answer has already come, feel free to just skip it. But I'm not 100% certain if you mean appeal or if you mean you can refile. Not recalled isn't necessarily a legal term of art that applies to the situation. So Yolanda, just for clarification, it is 6 years or 2 years for the penalty. It is not on top of the 6 years.
Yeah.
Alana, I just put the link for the court records database, MCRO, or I call it MICRO. Then
So the anonymous attendee said, yeah, I mean an appeal.
Okay.
So here's what I would say to just try to disentangle it a little. If you, by mediation, you mean like a negotiation, so you can only appeal a court case. You can't appeal something that happened privately outside of court, really. Maybe you can convince someone to listen to you. So if the negotiation didn't go your way, well, if you agreed to a settlement and you're just not happy with it, I gotta say it's a real long hike up a high hill to get it undone. I've seen it happen once. I can't say it's literally impossible. I have to say, if you agree to a settlement and then you go home and you're not happy, you're probably stuck with it. If you're not happy with how the court case came out, that you can definitely appeal. If you are required to mediate something and that's actual mediation, it's usually governed by internal processes. Like if you're talking about like with a public housing authority or an appeal for benefits determinations or something, those are governed by more internal processes. The advice we're giving about is really what's happening within the four walls of the small claims court. So I hope we answered your question with that. Generally, you can appeal the judgment. If whatever the court decided, that's what you can really appeal.
All right, and so that was that. Yolanda, I see you. We have scheduled our webinars for the rest of the year this year, but absolutely something we can add on for potentially a topic for next year. It is a big topic, so it may not fit into a 90-minute webinar. There are other organizations that also kind of specialize in those subsidy programs that may already have things out there. Law Help MN is the legal aid group resource website. I'll put that in the chat here in a second. They have a lot of really great resources for things revolving around subsidies and discrimination as well.
If I could put one plug in there, if you're talking about disability determination, contact the Minnesota Disability Law Center. They can help any disabled person of any income. If you have a legal disability, legal as in defined under the law, they can help you, and they may be able to help you for free. They work statewide. So if it's a disability related question, the Minnesota Disability Law Center, they are an incredible resource. They have incredible lawyers, and they really care. My experience with them is that they really care a lot.
All right, trying to get. All right, there we go.
They if it's disability discrimination related to housing, they may be able to help. I just saw a question in the chat. They don't do housing. They don't just do strict housing issues. Tamara, you said your hearing is next week. Please reach back out to the attorney you're working with, or reach back out and we'll connect you with them. We'd love to advise you further.
Yep. And then I saw in the chat as well something about accommodations for the court itself. There is a accommodations request form that you can use for if you need something like a interpreter, or if you aren't able to do like phone in over Zoom or something like that. You can there are accommodation request forms that I will get in the chat here in just a second. But I think that is it. So thank you both so much for all of your expertise in this really helpful webinar, just kind of breaking this all down. It can be intimidating, but it is also something that folks can do. So I hopefully this will help spur on folks to get a little more access to justice. So with that, I'm going to sign everyone off. Thank you again all so much. Again, the recording will be up on the website shortly, and hopefully we'll see you next month. So bye, y'all.